It's very similar to an aggravated assault, discharging a weapon somewhat in the direction of the complainant. In this case, I have had multiple conversations with Jeremy Shelton, the complainant. He is the across the street neighbor of Mr. Church. He is a very nice young man. He was very forthright, came in and presented me or had an affidavit authored by himself with one of my investigators in lieu of coming to docket today. He as the court can probably surmise, is of the mind that he doesn't want to aggravate the situation. Nope, not intending to use that same word, but I will tender that as State's Exhibit number 1, just for purposes of this hearing. And I have Mr. Gertz, it's his affidavit just expressing concern about the nature of this offense and the fact that they reside across the street from one another, that he has a very young son and a wife who were also present at the time of this offense. And he has concern that Mr. Church may be keeping weapons at his sister's house down the street. I have worked very closely with my investigator, Mr. Bays, and he is familiar with Mr. Church as well as Port Arthur Police Department is. We've asked that some things be implemented in the interim time period to hopefully assure the safety of all the parties, including Mr. Church. I just wanted to bring this matter to the court's attention with that motion. It's not necessarily intended to increase as much as it is to modify with the admonishment regarding weapons, etc., because obviously it's difficult to remove these two individuals from one another approximately because of where they both reside.
Any objection to me reviewing that?
Well, Judge, the rules of evidence don't apply in a bond hearing, so I would love to have some great evidence, but I don't have a good one.
Then I'll state the ones admitted for purposes of this hearing. Give me just a second, please. Mr. Gertz?
Judge, I'm happy to discuss bond conditions. $20,000 is more than sufficient, though, in terms of amount for this allegation as it stands right now, or as it's indicted right now. Mr. Church wouldn't, I think, object to the normal conditions of not having any contact with the complainant, not possessing any weapons.
Those are already conditions.
Right. I'm not sure what else. Given what else the court could impose, because of the proximity of their homes without infringing on his constitutional property rights of his own. But I think the fact that he's, hired counsel, has shown up to court, he's taken this seriously. He's not been threatening the complainant or anything of that nature. I understand the complainant may have concerns, but those are the complainant's concerns. They're not being triggered by anything, no pun intended, by anything that Mr. Church has done since his arrest or his indictment. And so, and he's not violated any of his bond conditions that
I think
that I'm aware of, or that
is if they feel like he is watching, could be, just uncomfortable. There's an allegation that he's sitting in his car watching family, obviously based on the nature of the offense and the allegations and the probable cause. That would give me some concern too if I lived across the street and that had actually happened. So,
but I don't think I just don't think raising his bond and just charging him more penalty is the proper remedy for that. So I'm not sure how the court remedies that. I don't see
the way it gets remedied, Mr. Church, is if you're doing anything that's making the person uncomfortable, that's the complaining witness in this case, the only way for me to take care of that is to put you in jail. Then they don't have to, nobody has to worry. I don't want to do that, but I need you to understand that there's no way around if, you're not contacting them or talking to them. I get that. But if you're doing other things, like sitting in your car and watching them, then That's going to be of concern to me.
Yes, ma'am.
So I'm ordering you, here's what I'm ordering right now. Listen to what I'm going to say very clearly, okay? This no contact order is going to include literally looking that direction. You can't sit on your front porch. You need to sit in the back. You can't just sit in your car for no good reason. People don't do that. So you're not going to do that. Do you understand?
Yes, ma'am.
So if they feel uncomfortable, they're going to let Miss Malfino know, and you're going to end up in jail. So I understand you live across the street, but if I were you, I'd walk. If I was going out my front door, get in your car and leave if you're going somewhere. No lingering, no looking that direction, no standing there watching. Otherwise, you're going to end up in jail because I won't have any other choice. Does that make sense?
Yes, ma'am.
Okay. So we'll reset this for an announcement. Make sure you stay in touch with Mr. Gertz, visit with him before that next court date, and we'll see if we can get an announcement, okay?
Yes,
You're
ma'am.
free to go.
Thank you.
Oh, here. One of those is just what I printed out. Do you want the exhibit or does that go in the file? That discussion supports like this. Good morning. You are Amber Bruno Walker. And this is cause number 25, DCCR 1814. Ms. Bruno Walker was previously in court, entered a plea of guilty to the state jail felony offense of driving while intoxicated with a child passenger. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
The state has, Judge.
Are there any additions or corrections?
None from the defense, Your Honor.
No additions or corrections. However, I do have a comment or a question,
Sure.
and it relates to the defendant's version on page 2. Your Honor, I don't know that it's a full-throated admission of guilt. She refers to this incident as being a distracted driving incident, when in reality it was a rollover crash. She was essentially not cooperative and required a blood search warrant to get her blood.
I made note of that as well.
Judge, I would add to that though is, she did acknowledge in that same thing, although it's not lengthy that they listed, she did also acknowledge in it that this was her responsibility. She said, responsible for
I mean, you tested your blood alcohol by the time they finally got it was 0.0986.
Yes.
I mean, so you definitely were above the legal limit. Are you disputing that?
No.
Okay. So, Ms. Bruno Walker, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but that will be probated on for 5 years. So you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. So you're going to be regularly tested. The police version is that it rolled over.
Yes, ma'am, we do.
It did not roll over. Okay, that's just a. So,
Just so the record's clear, Judge, I got part on here. I showed it to Mr. Rennick as well.
okay. How's that not a rollover?
It's not, it's nothing to out.
I thought rollover mean like.
Well, it wasn't on all four wheels, was it?
Yeah.
While you had a child in there. So here's part of the important thing about probation is in order to be successful, you've got to completely take responsibility for everything you've done, all of the conditions that you're going to have to do. It gives me some concern that there's some diminishing of that by you right now. So it is very important that you take advantage of everything that you're about to have to do on probation, because if you don't, you're going to be right back in here and you're going to be looking at that 2-year sentence. You understand? So you are, do you currently have the auto ignition device on your vehicle?
Yes, I do.
Okay, so you'll make sure and keep that. Obviously, if there's any blows into that are positive for alcohol, it's a violation of your probation. If there's any issue and probation feels like you need anything more than just regular probation, you'll immediately be referred to treatment, whatever that is. It will be ordered by the court. You understand? You can't have a single drink of alcohol while you're on probation. And obviously you can't do anything else, whether it's legal or illegal, without a prescription. If you do everything you're supposed to while you're on this probation, this is a great opportunity because you'll be able to serve that 2-year sentence that you received while you're out on probation instead. But the other side of that is if you violate any condition of probation, you can be brought back into court and you could be your probation revoked and facing that 2-year sentence. You understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Rennick. All right, you just need to have a seat here in the courtroom. Yes, ma'am.
Occupational
Talk to your attorney about that. That's filed somewhere else separately from this. And so have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am.
Thank you, Judge. Thanks.